Who would you like to handle first?
We could go ahead and handle Mr. Adair, Your Honor. You have a couple of witnesses, family members.
The blue one's right there.
Yes, sir.
Just 1 second, Mr. Maddox.
Yes, Your Honor.
All right, go ahead, Mr. Maddox. I
Yes, Your Honor. So this
apologize
is
for that.
that's fine. This is Mr. Adair before the court in 26 CF 558. Your Honor, the state has informed me that they're not going to be moving forward with pretrial detention, so this will be a bond hearing. I do have a couple witnesses whenever the court is ready for me to proceed.
Sure.
Okay. So I'll just a couple brief remarks, Your Honor. My main concern with, first of all, I'm seeking a $10,000 cash professional bond. Now, candidly, with the court, Your Honor, it's alleged to be over 900 grams of meth. I understand that's going to cause grave concern for this court, and I understand the facts are relatively scant at this point. However, with Mr. Adair, he's in the jail right now. He has informed me that he's been diagnosed with bipolar disorder and schizophrenia. The jail is refusing to give him his medication, which is of grave concern to the defense because that's going to affect his competence to proceed and affect his overall mental health, Your Honor, and affect his ability to assist me with his defense here in this case. I do have a couple family members here. Actually, I have most of his family here present. Candidly, with the court, Your Honor, most likely Mr. Adair would be living in Alabama with the family. However, the family has communicated to me that they'd be able to get him to and from court, get him his medication, start him on the road to, medicating him, get his mental health back in shape, Your Honor. I will be doing a competency evaluation. They can assist me with getting him here. And so those are the main concerns of defense at this point and why we are asking for a $10,000 cash professional bond. That being said, we are amendable to a GPS monitor to ensure we know where he is at and ensure he comes to court. We are also amendable to any safeguards that the court deems appropriate to ensure his appearance. If I may call his mother, Your Honor, Barbara Adair, to briefly testify to these facts.
Sure. Podium's fine. Ma'am, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir,
Okay, ma'am, could you just state your name for the record?
my name is Barbara Adair.
Okay, how do you know Harold Adair?
He is my son.
Okay, would he be able to stay with you?
Yes, he will.
Okay, without going too much into the diagnoses themselves, could you briefly tell the court his mental health status?
Bipolar, schizophrenic, and incompetent.
Okay. Would you be able to help him get his medications?
Yes, I will.
Help him to get to his appointments?
Yes, I will.
Help him to get to and from court?
Yes, I will.
Okay, where would y'all be residing?
Enterprise, Alabama.
Okay, about how far away is that from here?
About an hour,
Okay.
hour 20 minutes.
Do y'all have reliable transportation to ensure he gets to and from court?
Yes, sir.
Do y'all have reliable transportation to ensure he's able to get to any evaluation that would be court ordered?
Yes, sir.
Okay. Could you tell us briefly about Mr. Adair and could you tell us briefly about you as a mother and Mr. Adair, how that's been?
He means well. He's helped anybody. He just got caught up in the wrong thing. Dealing with people think they was his friends. He see homeless people on the street with signs, ain't got money. He'll give it to them. He'll give them the shirt off their back. And he's a church going. He's church going. He got a good heart. And he just got caught up with the wrong crowd.
Okay. How much do y'all think the family could come up with for Mr. Adair in terms of bond?
Well, like I say, about 800 or 900, because I'm not going to sit here and say I'm rich and I got money, and I don't.
Okay.
And then he's also received disability.
Okay, thank you, Ms. Adair. I don't have any further questions. State?
Any questions?
Okay, go ahead, ma'am. Ma'am?
They're gonna ask us a question. You said that he was incompetent. How do you know that?
Cause he, when he went to court, 7 years, 6 or 7 years, might be less than that. I had took him to Niceville to get evaluated, and they dropped the charges on him because they said he was incompetent.
Okay, and was that a misdemeanor charge?
Yes,
Okay. Where does Mr. Adair live currently, other than obvious?
well, nowhere right now.
Okay, that's all I have, Judge.
Thank you. Judge, I don't think it'll be necessary to call Mr. Adair's sister. I believe that's everything that I wanted to advise the court of. So I will let the state speak now, Your Honor.
Judge, we would ask for a $200,000 cash professional bond with the GPS monitor and pretrial services, basically for the amount of narcotics that were located with Mr. Adair, which was close to a kilo.
And Judge, if I may just say, I don't believe, I'm not aware of any failures to appear for Mr. Adair, and then I don't know the extent of his criminal history, but I do believe it is relatively minimal.
And I will second that as far as the criminal history, Judge. It is minimal.
Thank you, Mr. Strauss.
All right, so I'm quickly reviewing the competency evaluation from 2019.
Okay.
Because it was in a misdemeanor case, there's no discussion about whether or not he was restorable.
Yes,
Because
Your
that's not something they do in misdemeanor court. But my concern, obviously, is regardless of those things, until they're addressed with something more contemporary, I don't know what the exact situation is, other than the fact that this is a search warrant case where nearly 2 pounds of methamphetamine was found. I'll be honest, in my 20-plus years of doing criminal work as a prosecutor, defense lawyer, and judge, we don't see that much very often, because if it's that much, it usually goes to the federal authorities.
Yes, Your Honor. Understood.
When you start talking about almost a kilogram of methamphetamine. So my concern is, despite the potential mental health issues, is the danger to the community issue, because 900 grams is not personal use. I mean, which means it's allegedly, I'm sure, being distributed. It's not just a large amount that one person happens to have. I don't know the circumstances of it. I can understand the somewhat implications you're making, but based on his concerns that he may be taken advantage of as someone who maybe can hold these things for other people. But until that's actually fleshed out and shown to the court, I have concerns about giving a very minimal bond for something as serious as, again, nearly a full pound of methamphetamine. Um, Was competency ever addressed in his 2017 felony case, to your understanding, Mr.?
I don't know, Your Honor.
Yes.
In fact, it was the family, in speaking with him today, that informed me that he had previously been found to be incompetent. So I have not looked at that history extensively, Your Honor. That'll be one of the first things I look into, obviously. And given that fact, I'm going to go ahead and request an evaluation for competency from this court, Your Honor, and I'll work on that and make sure Dr. Zeman gets out there as soon as possible to see him, or if he's released, coordinate that with the family, Your Honor.
And then the second, I mean, there's three things that we look at for bond hearings, right?
Yes, Your Honor.
Danger to the community, which I think I've addressed. Flight risk, where the testimony is that he's going to reside in another state outside of the jurisdiction of the court. And I understand promises by family members to make sure that he shows up for his court dates are one thing, but if he doesn't, I can't have a deputy just roll up to his house and pick him up and bring him to court.
Well, I will say, Your Honor, in speaking with the family, that there is an aunt who lives here in the state of Florida. It is possible that he'd be able to reside there. The reason I didn't ask about it is because I'm not sure yet, but that is something to work towards. So he does have some ties to Florida, Your Honor. He was living here in Florida at the time of this incident. There are obvious reasons for not going back to the house. So, that's just not a situation that is tenable at this point. Otherwise, he'd be able to go back there. But I don't think he's a flight risk, Your Honor. One of the things that struck me the most in speaking with Mr. Adair is his genuine interest in addressing his mental health. That was the first thing he said when I sat down to meet with him, is he's not on his medication, he needs his medication. The jail is refusing to give him
So was he on his medication before this?
Yes, Your Honor, he was taking medication. I don't know the exact timeframes that he was on
Do you have any
medication, but
evidence
yes,
of that, Mr. Maddox?
he was taking medication, yes.
Do you have any evidence of that, Mr. Maddox?
Not that I presented to this court today, no, but there's also,
Well, my concern is if they've known for 7 years that he has these conditions, and if he's not being properly medicated and now has a very serious, what's the minimum mandatory on this, Mr. Sprouse?
I believe it's 15 because this is the highest it goes.
On methamphetamine?
Yes.
what I will say, Your Honor, is that my client has told me that he's requested medication from the jail and that he's been refused medication. I don't
But you
have-
can't even give me
No.
any evidence that he was taking medication before this happened.
Well, it would have been impossible for me to gather records and that sort of information for today, Your Honor. I can certainly get it before the court as soon as I can get it.
Sounds like a plan. $100,000 cash or professional. GPS monitor. No possession of any controlled substances without a prescription. Or
Yes, Your Honor.
narcotics, obviously. All right. Anything else?
No.
I can revisit things when you provide me with evidence of things, Mr. Maddox. I'm not trying to be critical of you. You're
I understand.
trying to put these cases together in a day or two with information you received today. No, ma'am.
Yes, Your Honor.
All right, thank you.
All right. Yeah, I'll talk to him.
Yeah, y'all can talk to Mr. Maddox about it, but I can't just take comments from the gallery. The evidence has to be presented. Who do y'all want to take next?
Court's discretion on that, Your Honor.
I'd like to get through the,
I'm just moving this.
yeah, I can't see, I mean, we're gonna have to figure out, is there a way to lower it?
That work? Does that block you?
Oh, that's fine.
Yeah.
Okay.
Screwdriver or something.
All right, then let's just take them alphabetically.
Morris,
Morris, is Harris the one that's been dismissed? Okay. We handled Carroll. All right, so this is, Mr. Maddox, are you handling all of them today?
Yes, Your Honor, everything except for, Mr. Knight, who has hired Mr. Flowers.
Okay. All right, so this is Richard Edward Morris, 26 CF 551. I've got Jay Williams as being assigned to him. He's charged with crimes against a person or neglect of the elderly or disabled adult with great harm.
Yes, Your Honor, I do believe, the court has previously set a bond.
$50,000 cash or professional at first appearance.
At this point, I don't have much to add. If we're going to, challenge that, we'll file a motion, Your Honor.
Okay. All right, so Mr. Morris, what's being explained is the state's not pursuing pretrial detention. So that means it defaults to what the bond was at your first appearance. First appearance judge set your bond at $50,000 cash or professional. You're to report to pretrial services weekly by phone and monthly in person. Vacate the residence where this happened. No contact with the victim, not to be within 500 feet of the victim's vehicle, residence, or place of employment. You may return to the house once with law enforcement to recover your personal items.
So 50,000 was the bond?
Was the
Yes.
bond set at first
I made that
appearance?
last Thursday, so.
You posted it?
Well, they just wouldn't let me out. She said.
You
my bond-
posted a $5,000 cash professional bond and you weren't released.
That's exactly right.
Well, I think they have to give the 72 hours.
Right.
I'm not sure when that expired, without, kind of deep diving through this here.
Okay.
Who posted the bond, sir?
Sir,
Who posted the bond?
you mean the bondsman?
Yes.
Blair, Miss Blair, from,
What's the name of the company?
Bird.
Bird Bail Bonds?
Bail bond, yeah.
Okay. Well, if it's been posted, they should be able to post it now.
I gave her the money. I mean, she said she just couldn't get me out.
Okay.
For some reason, she couldn't tell me why.
Well, so what the situation is when you're at first appearance, the state indicated that they might seek pretrial detention by filing a motion based on the charge. They're not going to do that. The court at first appearance gave them 72 hours to do so. If they didn't, then you could bond out. So I'm not sure if there was a situation where they thought you couldn't bond out until today.
I don't know, I paid her on Thursday. She said she back, Sunday they gave me. Sunday came along and she said, I can't get you till Thursday. It's Thursday. I don't know.
Well, at this point, you have a $50,000 bond. I would reach out to them and see if they can go ahead and do that. But we'll certainly, I just want to find out what the issue was so I can make sure it doesn't happen to anyone else.
I'd like to.
And I actually had discussed this
Excuse
with
me.
my office, Your Honor. What I think would be best to do potentially is, if the time frame expires or something like that, is go ahead and submit a draft order through this court approving that the bond can be posted or something to that effect. I think that would facilitate, I don't know if that was the issue in this case, but if it was, then that would.
I have to find out what the issue is before I can come up with a solution. so.
Yes, Your Honor.
But I would like, if you find out, Mr. Maddox, bring that back to the court's attention so I can make sure this doesn't happen. Because that's the whole point of this, is to give people bonds without waiting a week
Correct.
to appear in court. And then it turns out that he could have bonded out 3 or 4 days ago. I want to know why he wasn't allowed to, if that was the situation.
Yes, Your Honor.
All right,
So it stands now, is it 50,000?
50,000.
Yeah, if you've posted it, you should be eligible for release. Yes, sir.
Okay, well, I don't know what she did with it.
Well, it's not, I don't think that's the issue. We'll figure it out.
Okay.
All right, thank you, Mr. Moore.
All right. This is Mr. Knight, Your Honor. He has Mr. Flowers.
Understand what is it? All right. All right, Mr. Knight, you're here in 26 CF 588. I think you're represented by, oh, I'm sorry, that's the wrong case number. Nope, that's right. Looks like Mr. Flowers is going to represent you, but there's not really much to happen today. So what happened at first appearance was that the judge gave the state 48 hours to file a motion for pretrial detention. The state hasn't done so. Is that correct, Mr. Sheik?
That is correct, Your Honor, and we had no intention to, so.
Okay. So the purpose of today's hearing goes away, that the state's not seeking pretrial detention. So at first appearance, that judge gave you a $250,000 cash or professional bond. And let me see, were there other conditions? I assume so.
No firearms or weapons, Your Honor, and then no contact with the victim.
All right. It looks like pretrial services, you're to report weekly in person to them, not to possess any firearms, weapons, or other destructive devices. You have to surrender all weapons, firearms, or destructive devices within 24 hours of release. No contact with the victim. It's my understanding, Karina, y'all live on adjoining properties.
Yes, sir.
So when I say don't go within 500 feet of the person's residence, obviously you can still reside at your home. Is there any concern with that, Mr. Sheik?
No, I spoke with the victim. The actual residences of their property line touches, but their residence it's over 1,000 feet away.
Okay. But do not have any contact with the victim, and that means indirect or direct contact, which means you can't try to contact the alleged victim through, third parties, whether that be, asking someone to pass along a message, no posting on social media about this person or the issue, not sending any sort of emails or text messages or anything like that. And the reason I have to spell these things out is because sometimes people say, well, I didn't realize that's what you meant. So it has to be clear that there's no attempt to contact the alleged victim in any way, whether directly or through another person.
Don't state I've yet to speak to my counsel, but I have already willfully signed off paperwork releasing and relinquishing my weapons.
Okay. All right. And I don't really want to talk to you any more than that because you have counsel.
Yes, sir.
It's my understanding that he's not here probably because there's nothing to accomplish today because the state's not seeking pretrial detention.
That's why I chose not to go earlier this morning, sir.
Okay.
Fine.
No, it's fine.
And Your Honor, Mr. Flowers has been in contact with the state, and he said he will most likely be filing a bond motion.
Okay. And we'll address that once it's filed and set on my regular docket. All right. Thank you, sir. All right, I think that's the end of our pretrial detentions, right? Mr. Nope, said you want to handle your morning cases?
I'd love to, you wish.
Parker?
Matt, as far as you know, the 130 inmates are here? The 130 inmates, are they here? Go ahead. Mr. Nopes. Thanks, sir.
Judge, just so I can announce on the record, we're here today on Terrence Parker. He's got 2 violations of probation, which is 23 CF 1799, that's a felony BOP, and 24 CF 1239, which is a felony BOP. He also has a new law violation, 24 CF 24 CF 2902, 24 CF 2449, and 24 CF 1816, and 25 CF 518. So Judge, the agreement with the state is he's going to admit he violated his probation. The state's going to no pros 24 CF 2902, 24 CF 1816, and 25 CF 518. So he's going to enter a plea to the new law violations of no contest to the 24 CF 2449. Count 1 is going to be, he's going to enter a plea to a lesser included burglary of an unoccupied structure. And count 2, grand theft. Judge, basically he's going to be sentenced to the guideline sentence on the score sheet of 32.25 months, Department of Corrections. Adjudicated guilty, he gets credit for all time served. All the VOP and the 1 new law violation would run concurrent. And then he'd have the court costs as listed in the legal assistance fees as listed.
All right, is that the state's agreement?
That is, Your Honor.
Okay. All right, Mr. Parker, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Terrence Parker, 6/22/1991.
Okay, and this is exactly guideline sentence, 32.250. Okay. All right, Mr. Parker, as announced, you're here in 2 VOP cases, 23 CF 1799, 24 CF 1239. Then you have the new law violations of 24 CF 2902, 24 CF 2449, 24 CF 1816, and 25 CF 518. I have the agreement that gives the terms that your attorney just announced. Is that the agreement as you understand it?
Yes, sir.
Have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
And is that what you want to do here today?
Yes, sir.
And so you understand that it's 32.25 months in the Department of Corrections?
Yes, sir.
All right. And do you understand, Mr. Parker, that you're certainly eligible for the credit for the time served that you have, but you may have different amounts of credit in each case? Do you understand that?
I think it's all together. I've been in jail like 18 months.
Well, I understand, but if you have some credit in the older VOP cases, you don't get that credit on your new case. So sometimes you have different amounts. So the jail will determine that. And if there's any issues with it, you can potentially petition the court and say, hey, they got it wrong, but I can't tell you what it is right now. Okay.
I told him that be watching. They normally do a credit.
They usually do a credit memo pretty quickly after sentencing, but if there's an issue with it, Mr. Nopes can bring that back to the court's attention. I just want to make sure you understand, because sometimes it's a situation where there's a pretty big difference, and someone thinks because I have this much time on this case, I'll get credit for it on this case, and then they're going to be released a lot later than they expected. I want to make sure that's not a surprise for you if it does happen. All right, Mr. Parker, are you satisfied with the representation and advice of your lawyer, Mr. Nopes?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement we're talking about? And do you understand that in the violations of probation cases, that if you had entered admission to your violation of probation, that there won't be a hearing where the state would prove, or would have to prove, what you did to violate your probation?
Yes, sir.
And do you understand that in the one new case you're entering a plea on, the 24 CF 2449, which is the third-degree felony burglary of an unoccupied structure, lesser included offense, and the grand theft, third-degree felony, you understand if you enter the plea on that case, there won't be a trial of any kind.
Yes, sir.
And you understand that you're giving up your trial rights, which start on page 1, and looks like they finish on page 1 of that document that you've signed.
Yes, sir.
All right. You understand you're waiving any potential defenses that you may have in any of these cases in which you're entering a plea.
Yes, sir.
And do you understand that if you're not a U.S. citizen, these pleas could lead to your deportation or exclusion from the country? All right. As to 23 CF 1799 and 24 CF 1239, what is your plea to the violations of probation? Are you admitting or denying those? All right. I'll accept your admissions as freely, voluntarily, knowingly given. In 24 CF 2449, what is your plea to the reduced charge or lesser included offense of burglary, unoccupied structure, and count 2, grand theft?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. As to 24 CF 2902, 24 CF 1816, and 25 CF 518, does the state have an announcement?
It's no pros for plea to the other cases and charges.
Okay, so the other cases will be dismissed, as discussed in the plea agreement. All right, as far as your sentence, you're going to be sentenced on each of the 2 VOPs and the one new case to 32.250 months in the Department of Corrections with credit for all time served. Those sentences shall run concurrent with one another, just not coterminous, as we talked about the credit issue earlier. On the new case, that's the 2449, it's going to be 515 court costs. And on each of the VOPs, it'll be $100 cost of prosecution. In the 2449 case, it'll be a legal assistance fee of $150. In each of the VOPs, it'll be $100 legal assistance fee, so that'll be $350 total on the legal assistance fees. And I'll give you a year from your release from DOC to make sure all those get paid. All right. As far as your probation in the 2 cases, that will be revoked and terminated.
Always forget to write that in.
I forget to say it half the time, and then probation stands up and I say it. So, is there anything that I've missed?
Yes, sir.
Okay. All right, Mr. Parker, I do need you to be fingerprinted as to the new case, and you have 30 days to appeal the judgment and sentence of the court. Like I stated, this is a guideline sentence as you scored 32.250 months. All right, thank you, Mr. Parker, and good luck.
Thank you, Judge.
Thank you, Mr. Nopes. Have a good day. Oh, for the lesser included is 810.024, paragraph 4, subparagraph A. Of course. Except for the juvenile, okay. I don't have any lawyers for our 130. All right, ladies and gentlemen, if you're here for the 130 docket, we're a little bit early. And the reason I have to wait is I have to give kind of a big instruction to everybody all at once. So if I do it now and start early, I'm going to have to do it again once they get here. Also, the public defenders who would be assigned to people's cases are not present because they're to be here at 1:30 as well. So we're going to take a recess until just about 1:30, and then we'll get started and hopefully quickly get y'all out of here. All right, we'll be in recess until 1:30.
All rise, court is in recess.
regarding this particular case. Herefore, what I'm going to do is go through the docket alphabetically by last name. When I call your name, if you could just come up to the podium, to your left, my right. Excuse me. I'm going to verify you are who I called up, give you your case number and what you're charged with. You'll be handed a copy of the information or charging document for your case. If you're represented by the public defender or another lawyer already, they'll probably handle it from there. If you don't have a lawyer, I'm going to ask if you plan to hire one or if you would like me to appoint you one. If you do want one appointed, I'm going to have you fill out an application and turn that into the clerk's office on the first floor before you leave here today. All right. Are y'all ready with inmates as well?
I don't think the juvenile's here.
Is that number one?
Yep.
Okay. Well, just tell me when he gets here then. All right. Is it Jaron Anderson? Am I saying that right, sir?
Yes, sir.
Okay. All right, Mr. Anderson, you're here in 26 CF 290. Has an information been filed? Looks like it has, where you're charged with child neglect without causing great bodily harm. There's a copy of your information, Mr. Anderson. You're represented by the Public Defender's Office, Mr. Maddox.
Yes, Your Honor. One your plea of not guilty at this time, demand trial by jury.
All right, are you going to want the April pretrial dates for everybody?
Yes, Your Honor, that's fine.
Okay. All right, Mr. Anderson, your next court date's going to be April 27th at 1 p.m. Stay in touch with Mr. Maddox, your attorney, and I'll see you back on that date.
Yes, sir.
All right. All right, Carson Arnett. You didn't meet? Oh, that's right. They asked me about that yesterday. All right, so put him on, is he in custody?
He is, Judge.
He is? Okay. So it'll be April 29th at 9 a.m. for pretrial conference for Mr. Arnett. All right, Brett Barlow. All right, are you Brett Barlow?
Yes, sir.
All right, you're here in 26 CF 300 where you're charged with possession of a firearm, ammunition, or electric weapon by a convicted felon. Do you understand the charge, sir?
Yes, sir.
All right. You're already represented by the Public Defender's Office. Mr. Maddox is here.
Yes, Your Honor. One your plea of not guilty, demand trial by jury.
All right, and you did get a copy of the information as well.
Yes, Your Honor.
Okay. Mr. Barlow, your next court date's going to be April 27th at 1 p.m. Stay in touch with Mr. Maddox, and I'll see you back on that day.
Yes, sir.
All
Thank you,
right.
sir.
Travis Bice.
Good morning, Your Honor.
Oh, Mr. Rare's here for Mr. Bice.
Yes, Your Honor. I have not filed notice yet, but Mr. Bice is in the process of hiring me, but we are going to enter a plea of not guilty today, and that's for the next pretrial.
Okay. All right, Mr. Bice, you're here, this is a 24 case?
It was a direct file case, Your Honor, and just got served.
All right, 24 CF 1434, it's an insufficient check. Let's put it on April 27th at 9 a.m., Mr. Rare. And I'll tell you, Mr. Bice, even if you don't have Mr. Rare or any other private attorney, you'd still be on that same docket. So just make sure you show up 4/27 at 9 o'clock.
Yes, Your Honor.
All right, we'll see y'all back then. Do you have something later, Mr. Rare?
I've got one on the, I guess, the 2
2 o'clock docket.
Right.
All right, we should get to that relatively quickly.
We might be able to handle, it's very quick, Judge. I don't know if the court will allow us to call that. It's,
What are we doing with it? I'm trying to remember which one it is.
It's Hamilton, I don't,
Judge, it's a VOP Marcus Hamilton, 24 CF 2014. I believe the state was going to request a dismissal of the VOP.
yes, Your Honor, I was gonna ask.
Certainly not worth waiting for, but why wait? All right, so this is Marcus Hamilton, 24 CF 2014.
I'm asking the court to dismiss the VOP.
Okay, and I reviewed it again yesterday, last night, and I'm aware of the facts of it, so based on the state's request, I will go ahead and dismiss the VOP against Mr. Hamilton. Is he here?
He was supposed to be judged. I think he's running late today.
I just want to make sure he knows that just because we dismissed the VOP doesn't mean he's off probation.
No, absolutely.
It's a common misconception, so I want to make sure.
No, he's been back reporting since he bonded out.
Okay.
So I'll convey that to him again.
Okay, all right.
I believe there's still the new charge, 26 CF 326, unless it's been filed. But I think the state was going to handle that.
Yes, before next pretrial, the state will likely dismiss that.
Okay, but that's already set for pretrial?
I believe it is. We have a state.
It should be, yes.
All right, perfect. Well, we'll possibly see you then or not.
All right.
All right, thank you.
Thank you.
Make sure you tell Mr. LaPella how quickly you were out of here. All right, Christopher Chisholm. All right, are you Mr. Chisholm?
Right.
All right, has information been filed? Looks like it
Yes,
has. All right, Mr. Chisholm, you're here in 26 CF 409, charged with child abuse without causing great bodily harm. Do you understand that charge?
Yes, sir.
All right, and you've got Mr. Maddox from the Public Defender's Office with you.
Yes, Your Honor.
What would you like to do?
Will enter a plea of not guilty at this time.
All right.
And demand trial by jury.
All right, pretrial is going to be April 27th at 1 PM, Mr. Chisholm. Make sure you come back on that date. Stay in touch with Mr. Maddox. All right, thank you, sir.
And then, Your Honor, I do intend hopefully to get a motion to address bond conditions with respect to contact. I'm hoping to get that filed for a hearing on April 9th if possible.
Okay, just make sure it gets set and timely notice to the state.
Yes, Your Honor.
All right, thank you, Mr. Chisholm. Sean Cook.
Cook. I only have one information. You want the votes? We can just read it.
All right, hold on just a second, Mr. Cook. I want to make sure I've got everything I need here. 374. Oh, it's my understanding that, is it the 26 CF 375 was sent to county court?
That is correct, Your Honor.
And what was that charge?
It was felony battery and resisting without violence. It's now just going to be battery.
Misdemeanor battery?
Yes,
Okay.
sir.
All right, just so I can tell Mr. Cook. All right, Mr. Maddox, I think I've got you listed for Mr. Cook.
Yes, Your Honor. I believe we filed a motion to withdraw.
Okay, and I did sign an order on that.
Okay.
Looks like just a couple of days ago.
Yes, Your Honor.
All right, let's go through this now, Mr. Cook. You're here in 26 CF 374 where an information was filed charging you with lewd or lascivious molestation of a child under the age of 12. I have appointed the Regional Office of Conflict Counsel for you. Mr. Kleins, who would be your lawyer, is not here today. In fact, he's in a trial, in a murder trial down in the South End right now, so he's not here. What I'm going to do is enter a not guilty plea on your behalf. And he probably doesn't even know about the appointment because I just did it 2 days ago. And then I'm going to set you for your next court date. It's going to be April 29th at 9 o'clock. Mr. Kleins will come out and speak with you in the meantime. As to your other case, as you heard me ask the state, 26 CF 375, I sent that to county court as it's only going to be misdemeanor charges. We only handle felonies up here. So you're going to get a new court date for that once it gets properly transferred. And you'll see Judge Ward for that. Once you get a new court date, they'll transport you for that purpose. And then, does Mr. Kleins do the county court stuff too? Mr. Klein's?
I think so, yes, Your Honor.
Okay, so you may end up with Mr. Klein's on both cases in two different divisions, so that's certainly beneficial for you. All right. Any questions, Mr. Cook? I don't really want to ask you too much without your lawyer here.
No, sir.
Okay, so we'll see you back April 29th at 9 o'clock for your pretrial conference. And I've given you a copy of that information as well. All right, Delma Denman
He's an inmate, Your Honor.
comes.
416.
All right, so this is Mr. Denman. You're here in 26 CF 288, and information's been filed charging you with flee or elude law enforcement with lights and siren active, third-degree felony, and drive while license revoked, a second-degree misdemeanor. Mr. Maddox?
Yes, Your Honor, we'll plead not guilty and request trial by jury.
All right, April 29th, 9 o'clock for pretrial conference. We'll see you back on that date, Mr. Denman, and Mr. Maddox will come and talk to you. Leslie Dressman.
Mr. Dressman is present, approaching, Your Honor.
All right, this is 26 CF 335.
Yes, Your Honor.
Information's been filed and handed to Ms. Dressman, charging her with aggravated battery while actually possessing a firearm, which is a second-degree felony.
Actual discharge is how it's charged today.
That's not. Okay. The title doesn't include that, but yes, it is in there, so it's, did actually discharge the firearm. All right.
Yes, that is reflected in the information, Your Honor.
So it offers the 20-year minimum mandatory.
So it's
This
a
time, Your
10-20
Honor.
life case, man. Go ahead, Mr.
Went to a
Mayor.
plea of not guilty, demand trial by jury.
All right, Mr. Dressman, you're going to come back on April 27th at 1 o'clock. Stay in touch with Mr. Maddox, and we'll see you on that date. All right, thank you. All right, Gerald Gant. Oh, Mr. Gant, you were here all morning, weren't you?
Yes, sir. Trying to get the feel of things.
I'm sorry, what was that?
Just trying to get the feel of things.
Well, yeah, I understand. All right, so you're here on two cases, Mr. Gant. You've got 26 CF 214, and information's been filed charging you with felony petty theft. That's a third-degree felony. And then you have 26 CF 340. Information's been filed on that for failure to, let's see. Failure to register on change of address.
Are we appointed on 26 CF?
214, I don't think so.
Your Honor, we'll go ahead and request to be appointed to that case.
All right, so I'm going to appoint the public defender to that case.
I went to a plea of not guilty on both, Your Honor, demand trial by jury on both.
All right, April 27th at 1 o'clock will be your next court date.
My birthday.
Your birthday, but at 1 o'clock. You don't have to be here all morning again, Mr.
Gotcha.
I mean, you're free to attend and watch other things if you'd like, but you don't have to be here until 1 o'clock.
Yes, sir.
Unless your attorney tells you something different.
Yes, Your Honor.
All right, thank you, sir.
Sounds good. You must-
Gotti Gisclair or Gisclair? How do I say the last name, sir?
Just clear?
Gisclair,
Like a J?
like a J, like a Jeff, right?
Please put your phones on silent or turn them off.
26, 389.
Okay.
The information, count 2, the subsection is incomplete.
Oh,
so
okay.
it's not
I'm sorry.
filed.
All right. Who's the state on Mr. Gisclair?
It's me, Your Honor.
Okay. Clerk's office is saying that there's an issue with the subparagraph on count 2 of the 265 case, is that right? No, I'm sorry. I'm looking at the
389 maybe?
389, I'm looking at the OCSO number on the 389 case. So although I can see it, I think they're saying it's incomplete.
I'll review it and file an amended information.
I think what, I'm looking at it, and it just says, if you look in the last line, 943.0435, paragraph 4 and 9, where if you look at the one above, it says 4B. So I'm guessing they're saying it should have 4A or B or C.
Yeah, I
Okay.
understand you.
All right, so there'll probably be an amended information on that, but in the meantime, Mr. Disclair, you're here in 26 CF 389, charged with 2 counts of failure to register, and then on the 390 case, 26 CF 390, it's also a failure to register, all third-degree felonies. Do you understand that, Mr. Disclair?
Yes, Your Honor.
Okay.
Your Honor, winter pleas of not guilty on all counts, all cases, and request trial by jury.
All right, you're going to come back on April 29th at 9 o'clock. We'll see you back on that date.
And Judge, we have a juvenile here. We can handle
Okay.
him.
Back to it, sure.
We can just keep him, but I'm not him. Almanza? That's the flash right there.
Mr. Monza. Your Honor, our office has filed a motion to withdraw in this case. We currently represent the co-defendant, Elijah Murray.
Okay. Have you filed an order on that?
I do believe so, Your Honor.
I don't see one, is why I'm asking.
Okay, I'll make
I
sure
don't
we
see
get
one filed that I've signed, and I don't see one in my box to sign one.
Text-
So if you could make sure that gets sent over.
Yes, Your Honor. I'll text my legal assistant right now.
All right, so Mr. Almanza, you're here in 26 CF 319, where you're charged with home invasion robbery with a firearm, which is a first-degree felony punishable by life in prison. Do you understand that? Okay. So the public defenders indicated they've filed a motion to withdraw because they can't, there's, I think, 4 people who were involved, and so they can't represent everybody. So I'm going to appoint the Regional Office of Conflict Counsel once they send me an order, but I believe they represent one of the other co-defendants, so you'll end up being assigned a private attorney who takes those appointments. I just don't know who that's going to be yet until we go through that process. You will be set for a pretrial conference. It's going to be April 27th at 9 a.m. All right. What did I say? Should be the 27th because he's not going to have the PD anymore. Oh, he's in custody. Here I was worrying about 9 versus 1, and I got the wrong date. I'm sorry. It's going to be April 29th at 9 o'clock because you're currently in custody. All right. Thank you for correcting me on that.
Thank you.
All right. Thank you, Mr. Almanza. And once their attorney gets assigned, he'll come out and talk to you.
Should have that order, PD judge, by the end.
Okay. All right. Desiree Glover. Is Glover here? Is there? All right, so I'm looking at the arrest paperwork. It says March 26th at 13:30 hours or 1:30, has the address here, but I also see there's a notice to appear there. It says the same thing. That's to the bail bondsman. But there's also a notice to appear that was sent to her address that says 427 at 9 o'clock. Mr. Maddox, I think you're I've got the PD assigned with your name. Have you got any contact with Miss Glover?
To this point, contact with Ms. Glover, Your Honor.
I don't see a plea of not guilty, but for some reason, a pretrial conference date was sent out.
No direct contact with Ms. Glover to this point, Your Honor. That being said, if she was sent differing court dates, I would ask for an opportunity to attempt to reach out. There's usually a number or something in the first appearance paperwork or in the application if she's filled one out. We could at least try that. But I would ask the court to leave her set for the 27th.
Let's do this. Enter a plea of not guilty for her. I'll put her on the April 27th at 1 o'clock. However, if she doesn't show at that, well, then we'll talk about whether or not a KPS should be issued because for some reason she was given a notice of her next court date before we even had this one.
Yes, Your Honor. Thank you.
So I'm not going to have her arrested because someone did the wrong paperwork. Christopher Gavea. I understand, but once you get the second one that gives you a different court date, you probably think I'd only have to show up for the one. I'm not saying I would have done that, but I don't want people arrested because there's confusing paperwork being sent to their houses. All right, did I say that right, sir?
Yes, sir.
All right. All right, you're here in 26 CF 309. Information has been filed charging you with aggravated assault by threat with deadly weapon, 3rd-degree felony. Do you understand that?
Yes, sir.
All right. You do have Mr. Maddox as public defender for you. Go ahead.
We'll go ahead and enter a plea of not guilty, demand trial by jury.
All right, April 27th at 1 o'clock, Mr. Gavea. I'll see you back on that date. Stay in touch with Mr. Maddox.
Yes, sir.
All right, Joshua Green, please.
I appreciate it.
Thanks, guys.
Yes, sir.
All right, are you Joshua Green?
Yes, sir.
All right, Mr. Green, you're here in 26 CF 343, charged with possession of a firearm, ammunition, or electric weapon by a convicted felon, 2nd-degree felony, possession of a controlled substance, 3rd-degree felony, and driving while license suspended or revoked, 2nd-degree misdemeanor. Do you understand all that?
Yes, sir, Your Honor.
All right. And you already have the public defender assigned, so Mr. Maddox?
Yes, Your Honor. We'll enter a plea of not guilty, demand trial by jury.
All right, April 27th at 1 o'clock will be your pretrial conference. Mr. Green, show back up on that date and stay in touch with Mr. Maddox.
Yes, sir, Your Honor.
All right, thank you. Have a good day. Did y'all give him a copy of the information?
We did, Your Honor.
Okay. All right. Alicia Havens. Is Ms. Havens present?
Judge, we originally had Ms. Havens. We did a motion to withdraw on her case. Looks like we filed that back on March 4th.
I don't see an order for that one either.
Judge, I'll check on that and make sure that one gets out to you.
Usually they're the same day I get them and they turn right back around. That's weird for a couple of them to not have done that.
Yeah, normally she does it up when she does the motion. This is one of the motions that I don't draft, that she drafts. And so I'm surprised that the court doesn't have it.
Well, if you look into it and you find out that they're being filed and then disappearing somewhere in the portal or whatever, make sure we know about it so we can keep our eyes on it too. I just want to make sure that these things are getting signed in a reasonable fashion. Let's see. Notice to appear issued by the clerk to the bondsman for today's date. I don't see any other notices. If her arrest paperwork has a notice of her court date. I'm looking at her first appearance paperwork, page 5 of 7, which is the first page of the affidavit of complaint, shows this address, today's date at 1:30.
State would ask for a KPS, Judge.
Have y'all had any contact with her at all?
Judge, I have not, although I did not try to reach out to her and prep her for today because we'd filed a motion to withdraw. It's
Okay.
based on an actual conflict of interest.
I just don't see anything that would indicate why she's not here, like I did in the other case. So So I'm going to do a KPS but set bond at first appearance. So it looks like a notice to appear went to the bondsman as well.
Yes, sir.
All right, James Hicks. Are you Mr. Hicks?
Sir.
Over here. Mr. Hicks, you're here in 26 CF 385, and information's been filed and handed to you with a count of grand theft, third-degree felony. Do you understand that?
Yes, sir.
All right, Mr. Williams is already assigned to the case.
That's correct, Your Honor. Judge, I'm going to enter a plea of not guilty on behalf of Mr. Hicks. Request 15 days for any pre-arraignment motions. Ask Mr. Hicks to contact my office, make an appointment to come in and see me, and demand trial by jury.
All right, Mr. Hicks, we'll see you back on April 27th at 1 o'clock. Obviously, Mr. Williams has said he'd like to see you before then, so make an appointment with his office, and we'll see you back on April 27th, 1 o'clock.
Yes, sir.
Thank you.
Thank you, sir.
George Hillsman.
Judge, this is going to be a negotiated plea.
Ingram we already handled, right?
Sure. State signed too. Yeah. Judge, it is to a felony, so we do need a score sheet. Sorry, I thought I said something earlier.
I thought I'd asked you to.
I got it. Should-
So based on the fact that it's a withhold, that it's probably not going to be a downward departure. All right, let's get started. Mr. Hillman, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
George Owen Hillsman II in December 24th, 1993.
Okay. The plea agreement says junior, but the score sheet says the third.
Oh, sorry, Your Honor, that is actually, that's something in the state, I have a note on that one, for some reason, his social is listed as the third, I think, because there was an issue in the back, so that's our stack system, it's not in the actual.
Okay. Just wanted to make sure we got the right guy. You gave the right date of birth, but that's why we asked the question, Mr. Hillman. All right, Mr. Hillman, you're here in 26 CF 287 where you're charged with possession of a controlled substance, which is a third-degree felony, punishable by up to 5 years in state prison, and possession of paraphernalia and possession of less than 20 grams of marijuana, which are each first-degree misdemeanors and punishable by up to a year in county jail. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would call you for you to plea as charged. In return, to be a withhold of adjudication, 12 months of probation on each count to run concurrently or at the same time, $615 court costs, $150 PD fee, a substance abuse evaluation, any recommended treatment, as well as random urinalysis for the detection of any drugs or controlled substances without a prescription. Is that what you want to do today?
Yes, sir.
Have you gone over this agreement with your lawyer?
Yes, Your Honor.
Do you need any more time to do so?
No, sir.
And did you understand and sign the agreement?
Yes, Your Honor.
And are you satisfied with your lawyer's representation and advice in this case?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
As I stare at you. Has anyone promised you anything other than the terms of the agreement that I just read to you?
No, Your Honor.
All right, do you understand that by entering a plea, there won't be a trial of any kind?
Yes, Your Honor.
Do you understand that that the trial rights that are listed on page 1 and going on to page 2, you're waiving those rights by entering a plea? Do you understand that?
Yes, Your Honor.
Okay, and do you understand you're waiving any potential defenses that you may have?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, Your Honor.
You understand that? Okay. All right, and what is your plea to the possession of controlled substance, possession of paraphernalia, and possession of less than 20 grams of marijuana?
No contest.
All right. I'll accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication on each count, 12 months probation, shall run concurrently. For each count, 615 court costs, $150 PD fee, substance abuse evaluation, any recommended treatment, and random urinalysis for the detection of any illegal substances or prescription medicines without a prescription. This is a guideline sentence as he scored 16.60 points. Oops. All right, Mr. Hillman, I'll need you to speak with probation, who's sitting there behind you, and you have 30 days to appeal the judgment and sentence of this court.
Thank you, Your Honor.
Good luck to you.
Thank you. That one almost went over the edge. All right, we handled Marcus Ingram, correct?
We did, Judge, this morning.
All right, Sammy Lee Johnson. There's an amended information. Does it say amended?
No, this is,
What date was it filed?
I'm showing March 3 of 26.
There's one from March 9th. That's an amended information.
I did, March 9th.
Yeah, I can see it, but I want to make sure he gets the right one. Could y'all print one of those? All right, we're going to print you up a new copy of the amended information, but it charges him with failure to re-register during the month of his birthday or every third or sixth month. It's a third-degree felony. Mr. Williams, you're already appointed.
Yes, sir. I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motion, and trial by jury.
All right, Mr. Johnson, we'll see you back on April 27th at 1 o'clock. Stay in touch with Mr. Williams, and we'll see you back on that date.
Thank you, Judge.
All right, Tiffany Lackman.
This is for you. Hang that, or give it to your daughter, okay? She'll help you with it. Okay.
All right, is it Lackman? Did I say that right?
Lockman?
Lockman,
Yes,
okay.
sir.
All right, Judge, I'm going to enter a plea of not guilty on her behalf, 15 days for pre-arraignment motions, trial by jury.
Okay, just, you received an information, a piece of paper there, Miss Lockman?
Yes,
Possession
sir.
of controlled substance, third-degree felony. All right, we'll see you back on April 27th at 1 o'clock. Stay in touch with Mr. Williams.
Thank you, Your Honor.
All right, have a good day.
Thank you, Judge.
Johnny Howard Lee. All right, are you Mr. Lee?
Yes, sir.
All right, Mr. Lee, you're here on 26 CF 303, where you've been charged with abuse of an elderly person or disabled adult without causing great bodily harm, third-degree felony. Do you understand that? I'm not asking if you agree with it, just do you understand what you're charged with? All right. You currently don't have a lawyer. Do you plan to hire one?
No, sir, I'll get the computer sign me one.
Okay. Do we have the applications?
Might be down the room still.
All right. We're going to get you one of the applications, but I need you to fill it out and bring it downstairs to the first floor clerk's office and turn that in before you leave the building. But I'm going to appoint the public defender for you, Mr. Lee. That would be Mr. Williams, who's now standing next to you.
Judge, I'll enter a plea of not guilty on Mr. Lee's behalf, request 15 days for any pre-arraignment motions, trial by jury. Mr. Lee, I'm going to give you a card. I'm going to ask that you make an appointment and come see me, okay?
Yes, sir.
Here, I'll get it.
There you go. All right.
All right, Mr. Lee, make sure you get one of those applications before you leave. One of our deputies went next door to pick one up.
I gave one, the clerk had one.
Oh, you had one. Okay, so you just fill that out and turn it in downstairs in the first floor to the clerk's office before you leave the building, Mr. Lee.
Yes, sir.
But we'll see you back on April 27th at 1 o'clock. Stay in touch with Mr. Williams.
Thank you, Judge.
Thank you. Julia Lynch. All right, Ms. Lynch, you're here in 26 CF 360. You're charged with possession with intent to sell, manufacture, deliver, that being methamphetamine, second-degree felony, and possession of drug paraphernalia, first-degree misdemeanor. Do you understand those charges? All right. Mr. Williams?
Judge, I'll enter plea of not guilty on her behalf, request 15 days pre-arraignment motions, trial by jury.
All right, Ms. Lynch, we'll see you back on April 27th at 1 o'clock for your pretrial conference. Stay in touch with Mr. Williams in the meantime.
Thank you.
Thank you. Kevin McKinney?
Yes, ma'am.
Okay.
This morning, recommendation.
Oh, yeah, it's on my computer docket.
Wasn't when I checked a couple of days ago.
Well, we'll double check on that. Holly Maurer?
Judge, can you spell that?
Maurer. Apparently just got added to the docket. It wasn't showing up initially. All
And
right,
Judge, Ms. Maurer?
are you Miss Maurer? Okay, there's an information's been handed to you. You're charged with 3 counts of aggravated animal cruelty, third-degree felony. Do you understand those charges? All right, and you're already represented, well, is she represented? Yes. Go ahead, Mr. Williams.
Well, that's just what I was asking, Judge.
I see that the public defender was appointed. It looks like maybe nothing went through and processed through the clerk's site until today. I'm glad you're here, Ms. Maurer.
Judge, I'll enter a plea of not guilty on her behalf, request 15 days for any pre-arraignment motions and trial by jury. Ma'am, I'm going to give you a card. Call my office, make an appointment, come in and see me, okay?
All right, we're going to set you for a pretrial.
This is yours.
Pretrial conference on April 27th at 1 o'clock. Be back on that date. Stay in touch with Mr. Williams.
Yes, Your Honor.
All right, thank you.
On the refrigerator, it doesn't get lost.
All right, now do we have Kevin McKinney?
Do we approach on it?
Sure.
So, Judge, I'm going to ask that our office then be relieved if he's, another attorney's filed to.
Yes, it was filed today, and Mr. Tony, I know, was here early. So we'll go ahead and put Mr. McKinney, I'll allow the public defender to withdraw and be relieved. Mr. Tony is representing Mr. McKinney in 26 CF 333. They filed a waiver of arraignment and a plea of not guilty. We're going to place him on April 27th at 9 o'clock. All right. Zacharias Porter, inmate.
Does he have any information or once there's 2 cases?
The other case,
Is null prost.
that's correct.
Like I said, there was a null pros on 26 CF 378, but in 26 CF 334, information was filed where, Mr. Porter, you're charged with burglary of a conveyance armed with explosives or a dangerous weapon is a first-degree felony punishable by life in prison. Count 2 is criminal mischief, third-degree felony. Count 3 is possession of burglary tools, third-degree felony. Ms.
Your Honor,
Rivers?
we're going to enter a not guilty plea and request trial by jury.
Mr. Porter, I'm going to put you on a pretrial conference on April 29th at 9 o'clock. We'll see you back on that date. Ms. Rivers will come talk to you. All right, Alexis Richardson.
I have notes that he was placed on probation March 2nd,
Okay. Oh, he was this morning.
I'm sorry?
He was this morning? That's today's date, right? Okay, no problem. I think we handled him this morning, didn't we?
No,
No?
no.
Didn't we have a Richardson?
We had two Richardsons. We had
But neither of them
Adam-
were this one?
No, Your Honor, we had Adam and Clifford.
Oh, I was thinking of Richardson. Yeah, this defendant previously entered a plea on the 2nd of March.
Yes, Your Honor. Alexis Richardson entered a plea, March
At
2nd.
what kind of court date? I guess it doesn't matter, but. All right, so that case is already resolved. All right, Anthony Robinson. Pretrial detention date or something like that?
May have been, Your Honor.
All
Your
right.
Honor, if I may have just a moment with him. So do
Oh, we
you
must
have?
just put it on as an early plea or something.
Your Honor, if I could have just a few minutes with him, because this is his first plea agreement.
Okay. All right, so Mr. Robinson, Ms. Rivers is going to come back and talk to you in the back, and then we'll bring you back up to handle your case. All right, thank you. We'll see you back in just a minute. All right, Dwayne Seals. All right. Are you Dwayne Seals?
Yes, sir.
Okay, Mr. Seals, you're here in 26 CF 368, charged with failure to re-register, third-degree felony. Do you understand that?
Yes, sir.
All right. Ms. Rivers, you've been assigned to the case.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
All right, Mr. Seals, we'll see you back on April 27th at 1 o'clock for your pretrial conference. Stay in touch with Ms. Rivers.
The state said they're going to be looking at the paperwork.
All right, Robert Seals. All right, are you Robert Seals?
Yes, sir.
All right, Mr. Seals, you're here in 26 CF 291, and information's been filed.
Your Honor, we're going to enter a not guilty plea and request trial by jury to the charge of littering, illegal dumping.
Okay. All right, Mr. Seals, you're going to come back on April 27th at 1 o'clock. Stay in touch with Ms. Rivers.
No, that's all right. This is our next court date. In the meantime, you can call our office.
Can I just come up with it?
Thank you, sir.
All right, thank you.
Your Honor, this is Rekha Sexton before the court on 26 CF 359 with a charge of burglary of an unoccupied dwelling and criminal mischief. We're going to enter a not guilty plea and request trial by jury.
All right, it's going to be April 29th at 9 o'clock for a pretrial conference. All right, Michael Schumann.
But I'll be out to talk to you.
Okay.
Okay.
calling my book. Alexa.
All right, are you Michael Schuman? All right, you're here in 26 CF 331, charged with interference with custody, third-degree felony. Do you understand that?
Yes, sir.
All right, you don't currently have an attorney. Are you going to hire one, or would you like to talk to me about having one appointed?
I'd like to talk to you about having one appointed.
Okay. How long have you been incarcerated?
2 months.
All right. I'm going to go ahead and appoint the public defender for you. What's his bond? Go ahead.
Your Honor,
That's right.
we're going to enter a not guilty plea and request trial by jury.
All right, it's going to be April 29th at 1 o'clock for pretrial conference. Probably more like 1 o'clock, so yes, you're right, 9 o'clock.
Found it. This for you. You're on the black next to your attorney.
All right. Are you Mr. Tony? All right, Mr. Tony is here in 26 CF 361. Information's been filed. Do you have the amended information?
He does, Your Honor.
Okay.
And at this time, we're going to enter a not guilty plea and request trial by jury.
All right, and it's 7 counts of giving obscene material to a minor, lewd and lascivious exhibition in the presence of a person under 16, 2 counts. All right, Mr. Tony, it's going to be April 29th at 9 o'clock.
You want to keep this?
All right, Treywick.
See you tomorrow.
We're at the, on Treywick. Just try to.
Oh.
She is here.
All right, Paul Treaster. An inmate too.
Your Honor, I don't understand why he's not here. He's made all his office appointments with me.
So you just bonded out recently.
Yes, Your Honor.
All right, State.
Habeas, Judge.
All right, I'm going to do KPS with no bond, but if you find out there's a reason, you can readdress it. Are they ready with Treywick now?
Yep.
That's for you. Remember, there's on the blue X.
Your Honor, this is Von Seal Treywick for the court on 26 CF 406 on one account of possession of controlled substance. We're going to enter a not guilty plea and request trial by jury.
All right, Ms. Treywick, we'll see you back on April 29th at 9 o'clock for your pretrial conference. Thank you. All right, Gary Wright.
Your Honor, Mr. Wright is present and approaching. He's before the court on 26 CF 388. We're going to enter a not guilty plea and request trial by jury.
You're back pretty quick, Mr. Wright.
Well, Your Honor, he had the 2 cases and he bonded out on the 1.
I understand, we just pled to his other cases a couple of weeks ago, right?
Yes, Your Honor.
Aren't these new?
Your Honor, he was pled out to the 1 case, but the other case he bonded out. This is the
Okay.
case he bonded out on.
All right, Mr. Wright, we'll see you back on April 27th at 1 o'clock. Stay in touch with Ms. Rivers. All right, is there anyone else that's here that thought they had an arraignment? You are? Your name? That was a pretrial detention case, wasn't it? Zoe Harris.
Oh, that.
Yeah, Ms. Harris, your case was dismissed by the state.
Oh, it was?
Yes. So we had that one at 12:30, and when you weren't here at that time, we just announced it, and that was it.
Oh, okay.
All right, anyone else?
Hickson?
Hickson?
Yes, Arlene Hickson.
Nixon or Hickson?
Hick.
Hick, with an H, hotel, gotcha.
She's the co-defendant in Mr. Anderson's case, Your Honor, that I represent. She believed that her attorney had filed a written plea of not guilty.
I'm sorry, what?
She believed her attorney.
Who's she?
Ms. Hickson.
I don't see it on here anywhere. Do you have a case number?
Give me a second, Your Honor. I'll give you a case number for her.
Go ahead.
26 CF 289, Your Honor.
All right, looks like Scott Kleins represents Arlen Hickson. He filed a plea of not guilty. Let's put her for, what's it gonna be, April 27th at 9 o'clock for pretrial. I don't think she's actually here.
She went downstairs, I think.
Oh, huh. All right, anyone else on the arraignment docket? Yeah, is that everyone?
1:30? No, it says 3:30.
All right, I'm gonna bring in, we've got,
That's Mr. Treaster.
it's Treaster.
Yes, sir.
Where did Miss Rivers go?
You want to talk to that one?
All right, you can, I've already issued a warrant for your arrest because you weren't here, so stick around. When your attorney gets back, we'll address your case.
I have the case number. Yeah, okay. Actually, that's just on the email that I have the case number.
Do have a recall from this morning, Mr. Foreman, Your Honor.
All right, I'm gonna handle, I've got a case that somehow didn't end up on my docket, but
No
it's
problem.
all people on Zoom.
Yes, Your Honor.
Okay.
All right, can everybody hear me on Zoom? Yes? But can somebody respond out loud so I know that I can hear you? Oh, see, because I can't. Probably could have tried it over here. All right, try again. I'm not hearing anything. Sorry, we just did some quote-unquote improvements, and now I can't hear anything. It's probably user error on my side. All right, try now. No, I'm not getting any audio.
Yeah.
All right, that should be it. Can y'all respond?
Here's now?
I can hear a little bit. Let me turn it up, though. All right, I think that's it. Sorry, we just literally changed our system last week. And although it's just like the one that we had in Santa Rosa County when I was there, it's a little bit different than we had here. So I just have to fiddle with the buttons. I also have to apologize because although a notice of hearing was sent to my office, it didn't end up listed on the docket. I know what the case is and what we're here for, but I didn't really prepare for today because I didn't realize it was today until I was told y'all were waiting on Zoom. So I apologize for that. But let me get this. Let's see. 16 CF 2693. Oh, when I bring that up, okay. I think we're good, right? Oh, okay. All right. All right, gonna apologize for that. We're here in 2016, CF 2693, State of Florida versus David Russell Hullbrock. I know I've got Ms. Herndon from the state, and then I have Ms. Brigham from FDLE. Mr. Miller is from the Innocence Project. And Ms. Shirley, if you could announce where you're from.
From the Innocence Project in Florida.
Okay, I thought so, I just didn't want to misidentify you. All right, and we're here based on a motion that was filed on February 18th, was an amendment to the previously filed motion to dissolve the FDLE protection order. And I've previously reviewed it, but it's probably been a couple of weeks. Normally I would have read it again for today, but again, for some reason, didn't appear on my docket or any of my dockets for today. So who's going to be arguing it for the defense side? Ms. Shirley, you?
Yes, Your Honor, that's correct.
Okay. And let me just, I guess, ask Ms. Herndon, is there an objection from the state?
Your Honor, we are deferring to the position of FDLE.
Okay, and was there a position filed?
No, Your Honor.
Okay. Go ahead, ma'am.
And FDLE would be objecting for the record.
Okay. All right, so then, since there is an objection, Ms. Shirley, I'll let you make your argument, then I'll hear from, is it Brigham? Am I saying that right?
Yes, Your Honor.
Okay. Brigham. All right, so Ms. Shirley, I'll let you make your argument, and I'll hear from FDLE, and then I'll go from there.
Thank you, Your Honor. Just to provide a slight bit of background for the court, so we, prior to filing our motion to dissolve the protection order, we have reached out to trial counsel in Mr. Hullbrock's case, trying to get a copy of the defense file. And trial counsel informed us that they could not give us a copy of the file because of these protective orders that are in place. And so trial counsel is interpreting them very narrowly to mean that he will be prosecuted if he gives us anything related to the FDLE material in this case. So that's kind of the genesis of our motion. The motion itself asks for this court to dissolve two protective orders, one from 2017, which encompasses the entire FDLE file from this case. And then the 2019 order is FDLE material that was used as impeachment material by the defense against the state's expert at trial. And so we reached out to FDLE and the state attorney's office to see if they would be objecting to either dissolving the order or if they would be amenable to amending the current orders to include successor counsel being able to access this discovery material. And we were told that they would be objecting to that. And so In our motion, we laid out 3 reasons why the 2 orders should be dissolved, Your Honor.
Okay.
And so generally speaking, the orders rely on 2 provisions. One is Chapter 943.325, and the second provision is Chapter 760.40. And so these statutes, Your Honor, were enacted for privacy reasons, which are not at play here. We are not trying to obtain a random person's DNA profile from CODIS. We're not trying to use the DNA material for an impermissible purpose. We're simply trying to get the FDLE file related to Mr. Hullbrock's case that was disclosed during the normal course of discovery and that was inevitably used at trial against him. And so we're looking specifically at Chapter 943.325, Your Honor. While that on its face, subsection 14 is what's quoted in the order, appears to exempt the results of DNA analysis, that, in fact, when you read it in context of the entire chapter, has a very specific meaning. And so Chapter 943 refers to the collection of DNA samples from certain offenders, the testing of those samples, and then the inputting of those into the CODIS database and the state database. And so when they're talking about the results of DNA testing, it's talking about that exact purpose, taking a sample from an offender for the inputting into CODIS. And it does not contemplate, nor does it discuss, the results of DNA testing for the purpose of a criminal investigation or a prosecution. The face of the statute does not discuss that. The legislative history supports this interpretation, as well as the case law. So when you look at this chapter, Your Honor, it simply does not cover what we're here about today, which is DNA testing done for the purpose of a criminal investigation and prosecution of Mr. Hullbrock. And so therefore, it's not a valid basis for the prior protective orders, nor is it a valid basis for this court to maintain the protective orders. When you look at Chapter 760.40, those again talk about general privacy provisions regarding DNA information. And the statute itself specifically exempts DNA information obtained for the purpose of a criminal investigation. And so the concern of this statute has to do with DNA collected for other purposes, like a paternity suit and what happens to someone's DNA in that regard, which again is not applicable here. There is case law directly on point from the 2nd DCA as well as the 3rd DCA, which specifically hold that this statute, 760.40, does not apply in criminal investigations, nor does it apply in criminal prosecutions. And similarly, when you look at the staff analysis and the legislative history of the bill, that's exactly what is indicated. So again, it's not a proper basis to maintain the protective order, nor is it a proper basis for the underlying order to begin with. The 2 protective orders also mention the Florida Constitution as well as Chapter 119. And so the Florida Constitution in Article 1, Section 24 simply states that the public has a right to inspect public records. And then that is fully fleshed out in Chapter 119, but again, that's not applicable here. We're not asking for a public record. We have not made a public records request to the state or FDLE. We're simply trying to get a copy of trial counsel's files, which includes FDLE material that was used at trial and disclosed in discovery. And so when you look at Chapter 119, it specifically exempts material in discovery. So it says like this provision cannot be used to limit what trial counsel or post-conviction counsel would get in the normal course of discovery, which is exactly the kind of material we're discussing here. So again, it's not a proper basis to maintain the prior order. So we're respectfully requesting this court to either dissolve the 2 protective orders or to amend them to specifically include successor counsel, such as post-conviction counsel, being able to access the discovery material. And we believe that a failure to do so would violate Mr. Hullbrock's due process rights as well as his rights under the 5th, 6th, 8th, and 14th Amendments.
Okay. All right, Ms. Brigham, your response?
Yes, Your Honor. First and foremost, we do use these stipulated protective orders all the time with defense counsels. We're not keeping evidence secret because it can be used for the purpose of criminal investigation. So I will concede that. It does say that in the statutes. The problem here, and the Innocence Project puts it in their motion, is that their limited appearance is for the purpose of dissolving these two protective orders, for the purpose of deciding if they even want to represent him, not that they are representing him. So that's the issue that FDLE has right now. Additionally, FDLE would argue that raw data is not something that is given in the normal course of discovery. There's hearings that normally happen before that's given. Additionally, I did speak to prior defense counsel, Mr. Warwick. He said that the Innocence Project reached out in 2024, and he said that there's about, just in the DNA evidence alone, there's about 30,000 pages, and that he wasn't sure what he could give and what he couldn't give. But that was back in 2024. He also stated that he offered to file a motion with the court, and being that no motion was filed until now, 2026, I'm really not sure why the delay.
Well, let me ask, you said you talked to Mr. Warwick?
I did.
Is that Stephen Warwick?
I think it's Scott.
Scott Warwick, okay.
Scott.
Let's say if it's Stephen
yes.
Warwick, he got appointed to the bench in 2024, so that may have been part of it, but it sounds like it's someone else. I'm just not familiar with Scott Warwick.
Yes, Your Honor. Where was I?
I'm sorry, go ahead.
I did reach out to Mr. Miller and Ms. Shirley yesterday. I inquired if they had any reports at all. They stated they did not have any documentation from defense counsel. I offered to pull all of the reports and send them to the Florida Innocence Project. They stated they did not want anything from FDLE. They strictly wanted it from defense counsel. But again, the purpose of the objection is because they're not representing that they're going to take on and represent Mr. Hullbrock. They're only saying they want to see if they even want to represent him.
But I think the issue, and I can certainly let Ms. Shirley respond to this, they want to see what the defense counsel had at the time, I would guess, in order to make determinations beyond just their representation. So it's not what you could send, it's what prior defense counsel had in their possession, because that's also an important issue in pursuing these types of issues. So I think that's why they want it specifically from defense counsel, and frankly, I'm sure defense counsel can give a copy of their entire file to them to review before they ever decide if they're going to represent them, except defense counsel has said, we can't give this to you because there's a court order saying that we can't. So does that kind of sum up what your response would be, Ms. Shirley?
Yes, Your Honor, that's exactly right. I mean, we can't determine if we have a viable post-conviction claim without reviewing the file, so I can't promise I'm going to file a motion on something I haven't seen.
Okay. All right. Any other further response, Ms. Brigham?
No, Your Honor.
As far as I see, I don't think there's any issue with the court granting an order basically revising the previous order that would allow for current counsel, that being the Florida Innocence Project, to have to receive a copy of defense counsel's file, including these things that defense counsel would not give. Because again, I don't think Ms. Shirley is requesting a copy of FDLE's reports, but simply what was turned over previously so they can be reviewed.
That's correct, Your Honor. Just everything that was disclosed in discovery already, that trial counsel has.
Okay, perfect. All right, so Ms. Shirley, if you want to provide me with a proposed order, send it over to the other parties first, but I'll certainly take a look at that. And it'd be my intent to grant it for that purpose, the revision of the previous orders as opposed to completely vacating or removing those orders.
Yes, Your Honor, I'd be happy to do that.
Okay. All right, anything else that we have to address today?
No, Your Honor.
All right, and again, I apologize for the delay. We were just finishing up another docket that went a little bit over, and for some reason you didn't end it up on my printed docket, so I hadn't prepared, but obviously I'd read it previously. I just wanted to make sure I got everything down before I had the hearing. All right, perfect. Thank you, everyone, and if you need anything else from my office, make sure you communicate with Katie, my assistant, And if you want to just go ahead and email her directly, Ms. Shirley, that order, once Ms. Brigham and Ms. Herndon have had a chance to take a look at it as well to see if they have any objections to it, send it that way so we can get it signed for you more quickly. If it goes through the portal, as you can see with our technology issues sometimes, they're not always foolproof, so I appreciate if you would just send it that way.
Of course, Your Honor. Thank you.
All right, thank you all. Have a great day.
Thank you, Your Honor.
All right. Back to regularly scheduled programming. Mr. Sprouse.
I would like to call a case so I can dismiss it.
Okay. Go ahead, Mr. Sprouse.
It is the case of Benjamin Mack, 25 CF 2022.
Is that set for something today?
It's not set for today, Judge, but his time frame on the motion compel has run, and I suspect that they decided to do something with it.
Yes, I'm going to dismiss it.
Okay. That was the one I just signed an order recently, right?
Correct.
Kind of nunc-pro-tunc back to a couple of weeks ago.
Yes.
I'm not going to say too much on the record, but we're dismissing the case.
Okay, what was the case number again?
Yeah, it's 25 CF 2022.
All right, state has dismissed that case. If you could follow that up with a written all-pros.
I can do that.
Thank you.
And Judge.
Just because it's not on the docket for today, I don't want there to be an issue.
I do want to get with you on one of Mr. Sprouse's other cases. Mr. McDonald, I got a bunch of orders on the cases that I don't have and just wanted to get some guidance from the court on how you want me to go, and we can approach the bench on it later.
Why don't we address that later, since again, it's not on the docket for today. Let's get the people who are here.
I just didn't want, I had to get that done because of reasons.
Okay, I understand. But if you could follow up with the written. All right, who do we have left?
Your Honor, I previously had called Mr. Treaster,
Okay, Mr. Treaster.
Paul Treaster, and he is present, Your Honor.
Okay.
And I would ask the court to withdraw the capias.
All right, you're Mr. Treaster. You're here in 26 CF 362. Information's been filed and a copy given to the defense, charging Mr. Treaster with trafficking in amphetamine or methamphetamine, a first-degree felony. That's 28 grams or more. I'm sorry, go ahead, Ms. Rivers.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
All right, Mr. Treaster, is there a reason why you were late for court? Did you go to the wrong place, or?
I've been in the courthouse for a little bit, taking care of some stuff at the clerk, but a reminder on my phone says 3:30.
Not sure why I would say that. It might have said, your paperwork may have said 13:30,
And that's probably it.
which I'm not sure why sometimes they put it as 13:30 in the police reports, but the court works all in a 12-hour clock. So, but you're here now.
And as indicated, Your Honor, he has made his office appointment.
And that's what you said, Ms. Rivers. So I will withdraw the capias at this point. Just make sure that you're here on time and double check those ahead of time. Not a big deal, Mr. Treaster. We'll see you back on April 27th at 1 o'clock for your pretrial conference. Stay in touch with Ms. Rivers. All right.
Your Honor, I also have Anthony Robinson in custody.
Thank you, sir. You said that was going to be a plea, Ms. Rivers?
Yes, Your Honor.
Do y'all have anyone else for the 2 o'clock docket?
Stephen Arnett, Your Honor.
Okay. Well, we'll address it. I just want to make sure that I'm not missing something.
Your Honor, he just needs an opportunity to sign the agreement because he's in custody.
Thank you. Does he have any other cases?
No, Your Honor.
Or was it like a South End case? I just wanted, but that particular charge.
Your Honor, he was doing a program at the Okaloosa Youth Academy.
Gotcha. Say no more. All right. Mr. Robinson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
I was sent August 3rd, 2007.
2007? All right, Mr. Robinson, you're here in 26 CF 292. You're charged with battery on a detainee, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that? I've been handed a plea and sentencing agreement between you and the state that calls for you to plead to a lesser included offense of misdemeanor battery. It's a first-degree misdemeanor and punished by up to a year in county jail. Do you understand that? All right, but the agreed-upon sentence would be an adjudication of guilt, 11 months, 29 days of probation, waive costs of supervision, $625 court costs. Is that, can we verify that for simple battery?
622.
$100 PD fee, $50 application fee, and run concurrent with any Okaloosa Youth Academy juvenile sentence, right? Okay.
Yes, Your Honor.
Oh, wow. You're throwing some old acronyms at me I haven't seen in a while. All right, so Mr. Rob, 622, okay. So it's $3 less. All right, Mr. Robinson, did you have enough time to go over this plea agreement with your lawyer? Did you understand and sign it? Is this what you want to do today? Are you satisfied with your attorney's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've previously read to you? And do you understand if you enter this plea, there won't be a trial of any kind? And do you understand that you're giving up your trial rights, which are listed on page 1 and going on to page 2 of the agreement that you signed? Do you understand you're waiving all potential defenses? And do you understand if you're not a U.S. citizen, this could lead to your deportation and or exclusion from the country? All right, and what is your plea to the lesser included offense of misdemeanor battery?
No contest.
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, 11 months, 29 days probation, waive cost of supervision, 622 court costs, $100 PD fee, $50 application fee. This would run concurrent with any juvenile sentence that you have, but is he in custody on anything?
Your Honor, he was in the middle of a juvenile sentence, and now this, of course, violates that sentence, so he's
Okay.
facing yet another sentence.
But he's going to be on probation, but in custody. So,
I did start to outline some of that to the probation officer.
so his probation would toll while he's in custody? I don't think we place people on probation so they can serve their probation by when they're in jail.
Sorry.
Say again.
It's for a different offense.
Yes.
So it will be told.
So basically, your 1 year of probation would not start until you get out of custody. All right, you understand that, Mr. Robinson? All right. And I can tell you this is important because when I covered a docket in Escambia County a couple of weeks ago, we had this exact issue, and it was not discussed in the beginning, and ultimately, I had to terminate his probation despite the fact that he had been in jail during the entire probation sentence.
Your Honor, may I have just
Sure.
just a moment? Your Honor, based on the court indicating that this would be told, in speaking with him, I think it's appropriate that he withdraw his plea at this time. And we talk with the prosecutor, set this case for April 9th, and see about a county jail sentence, so he doesn't have to worry about trying to
Understandable.
transportation all the way back up to North Florida.
Okay, so his plea will be withdrawn. We'll set it on April 9th. At what time? 9 a.m. For, I guess, kind of a status as to what y'all are going to do with this case.
Thank you, Your Honor.
All right, thank you, Mr. Robinson. We'll see you in a couple weeks, see if they can get it figured out for you.
Can I have Foreman in the feed for another?
Oh, Foreman?
Yes, Your Honor.
Say on that one.
What does, what is the one? Okay, yeah, that's fine. Okay.
Those costs will just go to judgment, okay?
Alright.
Signing.
Is?
No, 26, March 26, 26. May I approach, Your Honor?
Yes. All right, Mr. Foreman, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Austin James Foreman, 01/31/1994.
All right, Mr. Foreman, you're here on a violation of probation in 21 CF 1984. I've been handed a plea agreement that calls for you to admit your violation of probation. In return, the court would revoke and terminate your probation, sentence you to 60 months in the Department of Corrections with credit for all time served, $150 cost of defense, $100 VOP fee, and you'd be adjudicated guilty, which you were on the underline. Is that what you want to do here today?
Yes, Your Honor.
Have you had enough time to review this agreement with your lawyer?
I do believe so. I do have one question, though.
For him?
I just want to know how much credit do I have again?
So the jail will do credit. That's the credit.
Okay. Okay, alright, yeah, that's fine. Yeah.
Okay, and although I'll give you credit for time served, I'm not sure what that number is, Mr. Foreman, and I
Alright.
can't give you anything that you could rely on,
Alright.
so. All right, is this still what you want to do today?
Yes.
All right, and do you need any more time to discuss it with your lawyer?
I think I'll be, okay.
Said no.
Alright.
You don't need more time? I don't really deal with ambiguity very well.
I do not need any more time.
Okay. I just have to make things are certain. All right, are you satisfied with your lawyer's advice and representation in this case?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No, Your Honor.
All right, and has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the terms of the agreement that I just read to you?
Say that
Has
one more-
anyone promised you anything in
No.
return for your plea?
No.
Okay. Other than the agreement that you have with the state
Yeah,
as to
yeah.
your sentence? Okay. And do you understand that if you enter an admission to your violation of probation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes.
Okay, I have to hear you for that. All right, and do you understand you're waiving any potential defenses you might have had to your violation of probation?
Correct.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes.
All right, and what is your plea to the violation? Are you admitting or denying that?
Guilty.
Admitting, yes.
Yes, admitting.
You're admitting your violation,
Yes.
correct? All right, I accept your admission as freely, voluntarily, knowingly given. I'm going to revoke and terminate your probation, sentence you to 60 months in the Department of Corrections with credit for all time served, $150 cost of defense, $100 VOP fee, adjudication of guilt. This is a guideline sentence, as Mr. Foreman scored 53.25 months. And did he have any monetary issues remaining with his probation?
Yes, Your Honor.
All right, those will be sent to judgment. All right, Mr. Foreman, I need to tell you, you've got 30 days to appeal the judgment and sentence of the court.
Yes. Anything else?
Does he have he has an offender status, correct?
Correct, Your Honor.
All right, so remember, even though you won't be on probation from this case, when you get out, you still have to comply with your registration requirements when you're released.
Understood.
All right, thank you, Mr.
Thank you.
Foreman.
Have a good one. Yes, you too.
All right, thanks.
Thanks, sir.
Yep.
And then I think we just have Arnett left.
Yes, Your Honor.